Alston Clare Law is a new type of law firm designed from the ground up to provide affordable, top-notch legal services to innovative, diverse, and entrepreneurial-driven companies and individuals. I'm also a legal advisor to Just Ad Astra, an international organization focused on bringing human rights to the stars, and I'm very excited to be here today. Within the next decade, humankind is going to return to the moon to stay, land a human on Mars, and see a proliferation of space stations in Earth orbit. And maybe I'm a little bit too excited for that. Maybe it'll take 15 years, but it's coming. And right now, with the growth of commercial space exploration and the coming switch from predominantly government and military astronauts to private citizens living and working in space, navigating these issues of jurisdiction and employment law and how private actors can enforce their rights in space is no longer a weird subplot from a sci-fi movie, but an actual legal question that we have to advise clients on. Unfortunately, our current international space laws focus largely, if not exclusively, on states as actors, and they do not provide mechanisms for individuals or private entities to assert any rights without going through a state agent. Thus, there remains much uncertainty for both private companies and citizens who intend to build, work, and live off-world. But private entities and individuals can prepare and minimize the risks connected with this unclear legal spacescape. So, first off, let's talk about current international space law. Now, the obvious place to start, especially as all of the major spacefaring nations are parties to this treaty, or currently, who knows what the future will bring, but they're currently parties to this treaty, is with the Treaty on Principles Governing the Activities of Space in the Exploration and Use of Outer Space, including the Moon and other celestial bodies, aka the Outer Space Treaty. Under the Outer Space Treaty, nations are responsible for activities that occur in space, whether such activities are carried on by government agencies or non-governmental entities, which would include private entities such as companies that are citizens of those nations. And nations are also required to both authorize and supervise these non-governmental entities. Now, building off of the Outer Space Treaty, we have the Convention on the International Liability for Damage Caused by Space Objects, or the Liability Convention. The Liability Convention holds nations liable for any objects they launch into space, thus creating jurisdiction, albeit limited in nature, which is tied entirely to the location of launch. This would mean that jurisdiction would be based on what country a space object, a term which includes even a landed facility or a portion of an orbital installation, was originally launched from. Of course, the problem with this approach is that different parts of an installation, like the different modules of the International Space Station, could be and frequently are multi-jurisdictional and governed by completely different laws based solely on their original launch locations. One can only imagine the confusion for an employer or a private citizen if half of an installation was governed by one set of legal rules and the other half by a completely different set of rules. Another issue with the Liability Convention is that Article 7 of the Convention creates a unique set of limitations for private citizens who are nationals of the launching state or nationals of other states who are invited to participate in the operation of that space object. Article 8 further limits potential claimants to states and not private entities, and Article 9 requires that states attempt to enforce any liability claims through diplomatic means or through the Secretary General of the United Nations. This means that private citizens or entities would need to have a state pursue any sort of damage claims on their behalf. And most importantly, private citizens and entities cannot use the Liability Convention to seek redress against their own states that they are citizens of, or ones that have hired or invited them to work aboard the space object that they are injured on. Another foundational piece of space law is the agreement governing the activities of states on the Moon and other celestial bodies, also known as the Moon Agreement. This agreement creates an international space commons on the Moon and other celestial bodies by prohibiting states from establishing sovereignty or claiming ownership over the surface or subsurface of the Moon or other celestial bodies. but it allows states to retain jurisdiction control over their personnel, space vehicles, equipment, facilities, stations, and installations. This control over installations and other facilities is extended to non-governmental entities, as states are required to ensure that non-governmental entities under their jurisdiction shall engage in activities on the moon or other celestial bodies only under the authority and continuing supervision of the appropriate state party. However, very few spacefaring nations are parties to the Moon Agreement, but the Moon Agreement is still instructive as it fleshes out some of the already agreed to concepts contained in the Outer Space Treaty, that sort of lack of sovereignty, and it evidences a well-established consensus that we should treat space, and to some extent other celestial bodies, like an international commons. It also reinforces the concept already found in much of our terrestrial international law that currently existing laws be given extraterritorial force in space, outside of the specific physical jurisdiction of a state. I know that's kind of a complex international law issue, but it's basically the idea that laws can apply outside of a physical border, which is what we're sort of used to when we think about civil rights and civil law. It's also worth noting that the Moon Agreement, which dates from 1979, was essentially the last attempt at creating a truly international space treaty. And while there's been much talk about the recent Artemis Accords, it is important to remember that the Artemis Accords are not binding law, and neither China nor Russia have signed onto them. And they once again focus on nationally controlled space agencies and are mute on setting ground rules for private entities or citizens living and working in space. Similarly, the Hague-Washington Compact on Norms of Behavior for Commercial Space Operations, which is supposed to help establish responsible and sustainable space operations for commercial and civilian entities, is also non-binding. So, a little bit confused by all this? Unfortunately, it's going to get a little bit more confusing because, as I've already touched on, unlike most civil law, current international space law is focused largely, if not exclusively, on national or nation-controlled space exploration. Thus, in essence, private and commercial actors do not exist in space. And this was not an oversight, but rather results from the intention of the original drafters to keep space exploration solely for states and not to promote the commercialization of space by private companies. So what you're seeing right now is an excerpt from a verbatim record of Mr. Hajek, sorry if I mispronounced that, from Czechoslovakia, speaking to the UN in December of 1962 regarding international cooperation in the peaceful use of outer space. And you can see how these thoughts that space should be kept devoid of private interests and purposes, devoid of private property categories, and devoid of proper profit-making interests shaped the Outer Space Treaty and later international space law agreements. But what the drafters of our space laws thought or wanted space to be like 60 years ago is not what it looks like today, especially in America, where private and commercial space exploration has simply exploded in the past few years. So, since there are no easy answers to these questions of jurisdiction and employment law in space, what can private companies and individuals do to prepare for a commercial future in space? First, we can draw, or we can extrapolate from current terrestrial solutions to similar problems in space to predict where space law is likely to go and plan accordingly. So let's look at the largest international commons on Earth, our international waters. If one were to extend current terrestrial law based on international waters to space, similarly to how existing international conventions and laws have been given extraterritorial force outside of the physical jurisdiction of specific nations, here we're taking this law and giving it literal extraterritorial force into space. We could adapt the current maritime registration system to space. Now, Articles 91 and 92 of the United Nations Convention on the Law of the Sea allow the owners of a seafaring vessel to pick the country they want to register their vessel with. And then they're bound by that state's exclusive jurisdiction while in international waters. And we actually have something similar for space already. The Convention on the Registration of Objects Launched into Outer Space also referred to as the Registration Convention, requires a nation to register any space object they launch into space in a national registry, which is shared internationally. And registered space objects can be and have previously been transferred between countries by one country removing an object from their registry and another country adding it to their registry. However, it is not entirely clear as to whether jurisdiction under the Liability Convention transfers with registration. And to date, it has not been applied to or used by private companies in the same way that they currently utilize traditional seafaring ship registries. But theoretically, owners of a space object could pick the jurisdiction of the country that they want to be bound by in the International Commons of Space and register their space vessel with that country. And assuming we could expand the Registration Convention so that it could be used by private companies and formally link space registration, liability, and jurisdiction, the result, particularly for civilians, employers, and tourism in space, would be a lot more legal surety. For example, space employees would be treated much akin to sailors, meaning that many employment law matters would be resolved by defaulting to national or federal employment rules. And I know it varies from place to place, but in America, a lot of our employment rules are state-based, which makes it incredibly complicated because there's no states in space. So what do you work with? But the snag with simply exporting terrestrial jurisdictional concepts to space is that we aren't correcting the problems that already exist within these systems back on Earth. And there are many more opportunities for exploitation and abuse in space. The wholesale exportation of maritime law extraterrestrially could simply result in the expansion of the concept of flags of convenience to space. Thus, there could be, as there has been for traditional seafaring ships, a race to the bottom with private companies registering their space facilities, installations, and ships with states that have the most favorable laws for them, such as those allowing for more exploitation of labor and less enforcement of safety and pollution regulations. For example, if you have a nation that's very focused on deorbiting your satellite within a certain period of time, do you want to register it with that company? Or if you're a satellite owner, would you want to register it with a country or a nation that has no rules or restrictions on this? So it could be a lot of people sort of using the system to find ways around rules they don't like. And it can also create significant enforcement problems if the only way to seek enforcement is suing, perhaps in a foreign country, back on Earth. Not to mention that there does not appear to be any enforcement mechanism for failing to register a space object, as not all current space objects are registered, which could lead to the creation of so-called pirate or lawless spaceships, facilities, and installations. But before we get ahead of ourselves, remember, we aren't there yet. And at least in America, we would need to enact specific legislation establishing, for example, that space employees are going to be treated like sea employees. So what do we do in the meantime? Because that's where we think space law is going, but we don't know for sure. So private parties are going to be forced to attempt to establish norms and create certainty via detailed contracts that establish general jurisdiction, describe what laws apply, detail any additional rights that might exist for space-specific issues if pre-existing laws do not set clear rules or merely set minimum guidelines that the parties want to expand upon. And also, they will need to define the location where one can sue or attempt to enforce these rights. And there are numerous terrestrial examples of such types of contracts, from the infamous forum and venue selection clauses for passengers on cruise ships, to the detailed agreements negotiating pay and other rights and duties that were common on ancient pirate ships. They actually have really good contracts on ancient pirate ships, which is sort of not what we think of. And then we also have like the basic of those international contracts between various private entities that often include venue, forum, and arbitration clauses. So there's lots of contractual examples that we can pull from and build off of. Now, of course, there are limits to the enforceability of such contracts, but there are many ways to draft such agreements to maximize enforceability and ethically attribute risk and benefits to all of the parties involved. Which brings me to one of the growing areas of space law that I am also most fascinated with: extraterrestrial employment law. So, unlike most traditional terrestrial employers, space employers will have to provide a place to live, food, water, and oxygen to their employees, And none of this is easy to source or find in space at this point in time. This raises the question of who will bear the cost of these necessary benefits. Will shelter and food be included as a term of employment, or will that come out of an employee's pay? Given the exorbitant costs involved, employees would be unlikely to be able to afford these necessities. We all know it costs millions of dollars to send an astronaut in space and to provide for them at the International Space Station. Imagine requiring a regular employee, a regular person to pay for that. They just can't. So a requirement that they pay for their oxygen or food would in essence recreate a system similar to a modern, but much more authoritarian and impossible to comply with company town, where an employee would be, they'd have no choice but to comply, to try to buy these things from their employer, because otherwise they wouldn't be able to live. And as this could border on involuntary servitude, such employment practices would likely not be permissible. In addition, it is unlikely that any court would uphold an employment contract with such potentially unconscionable and coercive terms that would require an employee to essentially pay their employer for their right to live. Now, another thing to think about is that what we consider normal HR practices back on Earth, they don't translate to space, which means employers are going to have to reevaluate all of their human resource protocols, procedures, and trainings, and carefully consider the makeup of their crews and how they treat their employees in order to ensure that human capital problems are as unlikely as possible to occur during the course of a mission. For example, take a situation where halfway to Mars, an employee tries to quit. The employee cannot simply leave the workplace. There's no place to go. They're on a spaceship in the middle of space. Nor can the employer stop providing them with life support, because that would essentially be terminating them or killing them for choosing not to work for you anymore. But a disgruntled employee who has tried to leave their employment could create safety concerns for the rest of the crew and potentially endanger the mission. So you sort of have to plan, like, how do we avoid this as much as possible? How do we make sure this doesn't happen? Or let's imagine a scenario where a crew member on yet another mission to Mars, and I'm choosing the mission to Mars because those are longer term missions that could last years, and there's no easy or quick way to come back from Mars. What if a crew member on such a mission makes a complaint of sexual assault against the captain? How do you investigate that millions of miles from Earth? You can't even have a live conversation back and forth. You can't examine the workplace. You can't do a medical examination that's biased or from a neutral third party. It's a quite unique situation. And you've got to think, would a crew member even feel comfortable coming forward? Or would they be too scared of retaliation when their life is essentially in the hands of the alleged perpetrator? How do you keep that crew member safe when all of the crew members are forced to live together in tight quarters? And separation of the complainant from the alleged perpetrator is physically impossible. Remember, we have very limited space in space, at least currently. Can't really, put someone else in a different wing of a building when there is no wing and you're all together and your sleeping quarters are together, your food areas are together, and your workspaces are together. Can your mission be successfully accomplished under such circumstances where you have this dynamic where you can't have these people cooperating together? They can't work together as team members, but they have to be able to, for the mission to succeed. Now, the closest parallel we have on Earth to something like this is Antarctica. And we know that incidents like this, incidents of sexual assault, harassment, discrimination, etc., they often go unreported until individuals return from Antarctica and feel safe enough to come forward. But Antarctica missions last months, not years, and there's usually less danger to everyone else involved in those kind of situations. And there's something else we have to think about. There's also a unique shift in the power dynamic between employers and employees in space. In space, employers literally hold the lives of their employees in their hands and could potentially permanently terminate their employees. Yet employees are going to be the ones who will determine the success of a mission and the safety of their employer's space infrastructure, both of which may cost employers millions or billions of dollars. In essence, there's what we might call a mutually assured destruction scenario. If either party demands too much from the other or behaves in an unreasonable manner, everything can go wrong. So space employees who feel they're being forced to work in unacceptable working conditions might simply hold a spaceship or installation hostage, or hold the completion of a mission as collateral during labor negotiations. Of course, the employer maintains a similarly strong bargaining position because they certainly control the survival of the crew. And any mutinous employees could face severe repercussions for their actions upon their return to Earth. So once again, things could get real messy real fast. So you have to figure out a way to balance all these different concerns and create a reasonable working environment. Now, another sort of interesting sort of part of space is the concept of time, because we're sort of very set right now in a world where we define a work week as 40 hours of work per week. And generally, if an hourly employee works more than 40 hours in a work week, they get paid overtime. And some jurisdictions even require overtime if an hourly employee works more than 8 or 10 hours in a single day. And these specific hourly cutoffs, they're not sort of irrational. They didn't just come out of anywhere. We base them on the fact that working over a certain number of hours in a day or week can result in negative health impacts, endanger the safety of other employees, and decrease overall productivity. And across the planet, the concept that there are 24 hours in a day, 7 days in a week, and 52 weeks in a year is nearly universal. However, as we leave Earth and move away from its orbit, what constitutes a day in a week will change. For example, a day on the moon is over 700 Earth hours long, and a day on Mars is 25 Earth hours long, but a Martian year is 687 Earth days. In fact, there's been a recent push to establish a universal lunar time zone so that everyone will know how time will actually work on the moon. But as we get farther and farther away from Earth, we may need to reassess what a working day is and how we'll determine overtime, if that even exists. And there is a serious question as to whether overtime will truly exist in space or whether one will simply be on call all the time, given the inherent dangers involved in living and working in space and the unpredictability of when one may be called into action. However, no matter how we end up defining a workday or work week in the future, space employers must be mindful not to create working conditions that are intolerable, and they should attempt to create working norms that are equivalent to what similar workers would experience back on terra firma. Because the last thing you want is a mutiny in space. We all know the cost and expense involved in building for space, and you don't want to lose a multi-million or billion-dollar investment because of bad labor practices. Also, there's just only so much that a human body can take over time, especially with all of the additional stressors that people have in space. So we have to figure out a way to make sure that people can work safely and productively for long periods of time in space. And adding extra hours to our day might not be the way to do that. Well, that concludes my presentation. I hope you all enjoyed it, and I'm happy to answer any questions you might have. You can also check out the Alison Clare Law website to find copies of some of my publications on various space law issues and recordings of some of the other space talks that I've given. And I just wanted to leave you with a bit more information about what Alison Clare Law does, which is provide legal services to clients across numerous industries, including aerospace and defense, SaaS, and traditional manufacturing. From contracts to compliance, from employment to general corporate and risk assessments, Alison Clare Law has got your terrestrial legal needs covered. And we're also on the forefront of the final frontier of the law, aka space law, working on issues involving jurisdiction, creating a space legacy for future generations, and the intersection of space law and employment law. So if you ever need help creating space employment policies, need a DEI consultant for your aerospace company, or looking for a space law advisor, we've got that covered too. And we also do mediations, arbitrations, and workplace investigations geared specifically towards the aerospace industry.
Perfect, wonderful. So probably hands down one of my favorite presentations that we had so far at this conference. Obviously, just because it personally brought up some of the points which I never really thought about, like from that standpoint, as you brought up, instead of, this presentation was more of raising the question points, and really putting it out there, because it's some really serious issues that have been touched upon and discussed, and we've been also discussing earlier today. So let me ask you a couple questions from today's earlier panel that we have not really figured, right? So as there is no preset norms or ethical, again, approaches, let's say, for space exploration, and as you said, it's mainly for the states that we have currently, the laws and the norms. So what if there's some resource or some, you know, natural resource mine that, let's say, two countries, for example, two states came across, and how do they actually divide that, right? Because they want to, let's say, mine it on the moon, right? So and let's say there's USA and there's a China, for example, and how do they again divide that without, you know, going into the conflict? And is it fair whoever gets there first gets it, or how do we divide it? And that becomes a different issue when it's actually not a country, but you're dealing with a private company, which is now again also trying to mine that. So I would love to get your perspective on that, Alison.
So I think that's a really interesting question. And I think it's particularly relevant because we've even seen sort of a switch in how, or I think there's been a switch in some of the messaging of the Artemis program, where at first it was like, return to the moon, diversity on the moon, all this exciting thing. And now it's a lot of like, well, China's going to moon to get resources. We need to beat them there. Like that's starting to be part of the dialogue. And I think it is partially a sort of a first there, first claim, because you're going to have a situation where I don't think people will want to create the tension that you might get with, you know, two people or two countries trying to get to the resources at the exact same time or sort of fighting over them. So I do think to a certain extent it will be first there, and then, you know, the second country isn't going to sit there and be like, well, I don't know if I really want to go to war over this or fight over this. I'll go to the spot next to it and try to use it. But it is important to remember that all these countries have agreed that no one owns the moon or any rights to it. So you get to access it, you get to use the resources, but you don't own the land itself that you're on. So I think that's kind of an interesting thing, because you could have a situation where somebody starts working on it, they leave for a mission. I could definitely see someone coming in and being like, well, you're not here right now. We're going to utilize these resources that you're not using. So I think there's going to be a lot of focus on sort of having a permanent presence there. I think private companies, you're really going to have to get the support of a country behind you that's going to be able to back up your claims, because right now that's how you're going to be able to enforce your claims or your access, is having someone else there to sort of protect you from the larger entity that might be next door trying to access the same resources.
Perfect. Awesome. That answers it. And we're getting close to the end of the session, but I got to ask you this one also, and maybe we can have a quick answer regarding that. And what would be, let's say, the procedure as you envision it for countries or states, or let's say the companies that will be violating those norms that will be preset? So how would there be some sort of a political punishment imposed on them, or what will be the step forward?
Well, ideally, I think that we would need to create some sort of special arbitration or tribunal, some sort of tribunal system for that specific region of space. And we've seen something successful like that. There's the Antarctic environmental protocols, which sort of everybody who's there and participating in research there or has a claim there, all the countries there, they've all agreed to be bound by certain rules and to bring any issues they have to this tribunal that they've sort of created specifically for that. And I think that would be sort of the best solution in space. Like if you're on the moon, you're going to participate in a tribunal that's focused solely on lunar issues, and it will know the best answers, and you've agreed to participate in it by going to the moon. I don't think our current system of let's work this out diplomatically without any structure is going to be successful in the long term.